Hello everyone, my name is Isha Mitruka and I belong to West Bengal, right now residing in Cochin. Very warm welcome to you in our legal aptitude classes. Today we'll be dealing with a very important topic for your CLAT examinations, which is intellectual property right. Can you tell me what is intellectual property right? Anything, even in a layman term, you can just put your comments in the comment box below. But to start off this session, let me tell you what is the definition of intellectual property rights, on the basis of which we'll be taking our classes forward. Starting off with the introduction to intellectual property rights. The concept of intellectual property rights is very important. That is why it's pertinent to know what it essentially means. When we're talking about IPR, they are the essentially legal rights which are connected to intangible assets. Now these assets can be in the form of inventions, literary works, designs, indications, symbols, words, anything. The categorization I will tell you about later. There are different types of IPR which includes all of this. Now when we are talking about the purpose of IPR, it's important to know that the purpose of IPR is to create a financial stability, to create cultural and societal recognition, and also to give exclusive rights to the creators of these IPRs. Now, if you think of a story in your mind, you have an idea and then you write down that story and that gets published. This is your creation, right? It's your intellectual work. It's come out of your intellect. That is why it's called intellectual property right. Whereas in the same scenario, if you have some story in your head and you don't write it, you don't publish it, then what happens? It just remains as an idea in your head and nobody gets to know about it. Then it will not amount to any intellectual property right because it has not come into existence. So another important point about IPR is it has to exist in some form, like a word, a story, artistic creation, a literary work, musical work, anything. But it has to be there. Just an idea is not intellectual property rights. Now, when we're talking about different types of IPR, like I mentioned before, we have several kinds. One is copyright, then there are trademarks, patents, designs, and geographical indications. Apart from these, I can name a few other IPRs. Can you? If so, please mention in the comments below. When we are talking about the legal foundation in India, there are different acts which governs different areas of law. You are CLAT aspirants, so you must know different acts governing different laws. Contracts law is governed by, I will leave that answer for you. Similarly, now we are talking about IPR rights, and then henceforth we will be dealing with these acts. Copyright Act of 1957, there's the Patent Act of 1970, we have Trademarks Act of 1999, and we also have the Geographical Indication Act of 1999. Geographical Indication Act, we get a lot of questions, geographical indication we get a lot of questions about. For example, there are different passages which talk about the domain, region. We have a lot of difficult and moderate level questions in the CLAT question paper. You can go ahead and search the previous year question papers and then you will get to know the pattern and the syllabus of intellectual property rights. In this slide, we will be talking about different categories in detail. Now, I have told you, if you could name some other IPRs in your mind out of just guess. Now we'll talk about trade secrets, which I had not mentioned in the previous slide, and also industrial property. Now this is a common term. It includes patents, which I have talked about, then trademarks, industrial designs, and geographical indications. Now industrial property includes a variety of IPRs. When we break it down, the first and the most important one, which most of you would be aware about, is copyright. When we are talking about protecting literary rights, musical rights, computer softwares or programs, and dramatic or artistic works, we always talk about copyright. Moving on to geographical indications. Geographical indications, they associate a product with a region specifically. When we are talking about basmati rice, we are talking about Darjeeling tea. That's what I mean by geographical indications. They are associating a specific kind of tea which originates from Darjeeling, and they recognize that tea to be belonging from that region specifically. So when you do that, geographical indication is what it comes under. Moving on to trade secrets. Trade secrets are such secrets or confidential information about a business that is an important component of the product, of how the business functions, and it gives the business a competitive edge. Now, for example, we have Coca-Cola and Pepsi. Both belong to the same industry, but when you taste it, it tastes a little bit different. So what is that component or a product or the edge that they both have against each other? These things are not out in the market. That's why they belong to trade secrets. So these important information belong to the companies and they are part of their trade secret. So this was the classification, the type of IPR. In short, we'll be moving on to more IPR categories in detail, which will cater to your CLAT questions. Like I mentioned before, we are dealing with copyright law first and foremost because it's the most important and most commonly recognized IPR. And you must see it in everyday cases or everyday news when you're watching a film or when you're listening to any music and any news comes up about that. So you can obviously recognize when and where copyright law comes into play. But I'll give you a more concrete example and a concrete dive into the copyright law. Definition wise, copyright is a legal right that grants protection to original literary work, artistic work, we have musical work, but additionally there are two other works that it recognizes. One is the dramatic work that is in theatres and cinema, which is also known as cinematographic work, and also computer softwares or programs. So it also provides protection to those aspects apart from these three that are mentioned in the slide. We have the nature of copyright, which, like I mentioned, it does not only protect ideas. Ideas are very intangible and they can be occurring simultaneously in more than one person's head or mind. For example, I could be thinking of some story and there's a very high possibility that the other person sitting next to me could also come up with the same idea. Then how do you know who is the original creator? The person who notes down the expression, who creates the expression out of those ideas first, is recognized to be the copyright owner. Now, duration of protection generally lasts for author's lifetime plus 60 years. This is very important to know because as long as a person has created some work out of these all domains and they have copyright over it, for the period of their lifetime plus 60 years after that, they will be having copyright over it. But after that, it comes into public domain and the copyright does not exist. Moving on, the governing legislation. Now, can you tell me what is the governing legislation for copyright? And can you spot the error here? Let me tell you. So, administered under the Copyright Act 1957, this is absolutely correct. So, under 1957 Copyright Act, copyright is governed. We also have the registration, all the rules, infringement, everything that covers copyright is under this act. But IPAB, which is the Intellectual Property Appellate Board, was abolished a few years ago. It was abolished because of the efficiency issues, and you can read more about that and come back to me. Okay, so let's deal with copyright infringement in a little bit more detail. So when we're talking about copyright infringement, there are three types of infringement that we can actually talk about. First is direct infringement. The second one being contributory infringement, and the third one is vicarious infringement. So direct infringement is when either you infringe upon someone's copyright, or if you're the copyright owner, somebody else infringes upon your copyright. For example, a very simple example that we have been discussing over these slides. If you write a story and you get published and somebody else writes the same story and publishes it, and there is no difference between these two, then that person could be said to directly infringe your copyright. That is very plain and simple infringement. When we are talking about contributory infringement, there's something, it can be direct, indirect. A person who is a third person is also contributing to the infringement. That person may not be the only one who is involved in this infringement, but a part of it. And the third one being vicarious infringement. When we are talking about a third party, even though through no fault of his or hers, an infringement occurs. For example, when you're living in a house and a tenant, as a tenant, and the landlord is also responsible for your acts. Similarly, in a copyright setting, when you're doing something, for example, if you're an employee in a company, and through your acts which violates intellectual property rights, the company is also held responsible. That is how you can differentiate between these three kinds of copyright infringement. Now, I've talked about infringement. You can see what constitutes infringement. Basically, what is it? Unauthorized use. It's a reproduction if you have used it without consent, if you have reproduced it in the market for commercial gain, or if you have distributed it without any permission. All these three will constitute the infringement. When we are talking about when there is an infringement or a violation of law, there's obviously some remedies which we can seek in the court of law or even without the court. So these things are injunctions, there are damages, accounts of profits and delivery of infringing copies. Under Copyright Act, you can always seek an injunction, that is you are stopping someone or stopping the infringer from particularly reproducing, using or distributing your work, copyrighted work without permission. Damages. So the amount of damages, the mental harassment, the financial accountability, everything that has resulted, the loss that you have incurred because of this infringement, you can gain back. You can actually file for it through damages. This is one of the civil remedies that we can look into. Moving on, accounts of profits. Now, if the other person, if the infringer has gained a lot of profits from your copyrighted work. For example, there are a lot of sellers in the market of fake purses like Gucci, Chanel, Louis Vuitton, etc. So those things, for those accounts of profits, they must have gained a lot of money. And if the original owner gets to know about this and seeks accounts of profits, all the profits from those sales can be given to him through the court of law, through that procedure. And also delivery of infringing copies. Apart from the injunction, damages, accounts of profits, delivery of infringing copies can also be gained. That is, all the infringing copies, all the fake purses can be stopped and they can be brought to you so that no other sale can be made in the future. Moving on, not only civil remedies, but there are also some criminal penalties that are applicable. They can involve imprisonment up to 3 years and also fine and up to rupees 2 lakhs under section 63. There are certain sections that you need to be careful of. Not important to memorize it, but it will be really easy for you if you do so, like infringement, registration, just 4 or 5 such sections in the entire, act. So that's very important. When we are talking about imprisonment or fine, both can be levied separately or together as a whole of your punishment if you are infringing anyone's copyrighted work. Moving on to the second very important intellectual property right, that is trademark. So when we are talking about trademark, it's basically the legal identity of a certain good or a product. Now what does that mean? I have mentioned here that it's a distinctive sign, but can you tell me what's the meaning of a distinctive sign? Let me tell you. So this is something that can be differentiated, which is very different from your everyday product or a very normal term or word or usage of a product. So distinctive means different. Now in that context, if you put that meaning here, what we can read is a distinctive sign, symbol, word or phrase legally registered to represent a business or a product. Now one very good example of it is Nike has just do it phrase in it, right? So it's very different. It has the mark of a tick. So whenever you see, even if you don't see the product name, which is Nike, but you do see this, you can always say that it belongs to this company, right? Same as Reebok, same with Johnson & Johnson, same with any car brands that you see. A lot of things are included under trademark law, and hence protecting their distinctiveness, their different products, their uniqueness, and the commercial benefits they gain out of this. Branding is very important in this day and age, and especially with the digital innovation and the digital step up that we have seen in this era, it's become more important. More and more cases are coming up with trademark law infringement, and that is why for your CLAT also you will get more questions, and you can see a pattern of trademark law questions in the upcoming papers. When we are talking about the purpose of trademarks, it prevents consumer confusion. This is a very critical point when you're talking about trademark, is creation of confusion. So it prevents a customer from being confused about two products. For example, I am taking your classes, somebody else with the same name takes your classes again, but it's not me. There'll be confusion, right? Now this is a general talk. When I'm talking about a trademark confusion, there are two shops. One is Dolma Aunties Momo, that belongs to Delhi. There'll be another shop right beside it. If you see Dolma Momos, the auntie is not there. You will still be confused. A consumer who does not know anything about those shops, he might think that this is just an extension of the shop, or the same person has two shops. So there can be n number of confusion because the product is the same, the person's name is the same. That is why that is where trademark law comes into place. Specifically, if you have, it's not important to register, but if you have registered your trademark, then it gives you an added layer of protection. If you have not registered, you still get protection, but under a different category. We'll talk more about that later on. And it also ensures brand recognition and goodwill. So brand recognition, for example, Nike. Very simple and obvious example, that Nike has built up its recognition over the years. Now you will know wherever you see it. So that is what trademark ensures over 20 years, 30 years, 40 years, any period of time. That's the shoes, the sneakers will be associated with the product, with the brand, with the specific brands. Now in the market, if you ask children, which are the sneakers you want, they'll say Reebok, Nike or Skechers, these 3 to 4 brands, right? But there'll be thousands of brands existing in the market. So that is the value of trademark. And also goodwill. Goodwill is the reputation. Now when you're talking about sneakers and you're talking about Nike or Reebok, then you will see that the reputation of the sneakers is built over the years, since the quality, the product is as such that they know that it will be good. So that is how trademark comes into play. It might look superficial, but it's very important when you're talking about any commercial product. Moving on to types of trademarks. So when we are talking about different types of trademarks, product marks are the marks I've told you about till now. It's regarding a certain product. And when you're talking about service marks, it talks about the certain services the company gives. For example, an airline company. You can associate with the trademark the kind of services it gives. And also a premium spa that you must have known about for ages, which is famous. So those things, service-based industries provide service marks. And collective marks. Collective marks are often referred to as certain groups, for example, chartered accountants. So ICAI deals with members who are chartered accountants rather than the public at large. So it, for example, ICSI or the Bar Council of India, which you will soon be a part of after your 5 years of law school. So you belong to Bar Council of India, you will be recognized as an advocate. You will be differentiated from other members who will not be an advocate. So that is the service mark, collective mark, sorry, and certification mark. Certification mark is such that you will be recognized with a different product. For example, your food, you can see the vegetarian mark, or you can see which company, sorry, which regulatory or regulatory body or authority governs it, that you see the FSSAI stamp. In jewelry, you see certain certification mark which gives you a surety that the product is genuine and authentic. So that will be certification mark. When you are talking about legislative framework, Trademarks Act 1999 I have told you about, this is the sole act that governs it, along with certain other rules that come up every once in a while when an amendment is needed. The term of Trademark Act, the term of applicability of trademark is 10 years. Every 10 years, the companies or the individuals can renew they can submit their application for renewal of their trademark, but they have to do so every 10 years. Moving on, to summarize, there are three important things when you're talking about trademark. It has to be a mark, word, symbol. It has to be graphically representative, and it also has to be identifiable, right? So that was all about trademark. Just as we discussed about copyright infringement, trademark infringement is also very important, and from a CLAT perspective, cases, a lot of hypothetical questions come about trademark infringement and the case laws that we deal with it. Sometimes the same important landmark cases are posed as a question after a paragraph. So if you know about some of the important case laws, then you will be able to see different, you will be able to connect the questions with the case laws and give your answer correctly. Let's talk about certain legal violations and judicial interpretations in India. When we are talking about infringement, again, the unauthorized use. Just remember, when we are talking about any infringement, the word unauthorized should come to your mind quickly, instantly. So unauthorized use of a registered trademark likely to cause confusion among consumers, because when we are talking about trademark, it's about a company or a brand. So it caters to consumers. So if there is a likelihood of confusion within the consumers, then there is a trademark infringement, provided there is an unauthorized use. There can be transferable trademarks as well. For example, consent has been given to some other person to use this trademark for a certain amount of time. Then you cannot claim trademark infringement. Then it's a valid use of the trademark. But there are different tests that have been developed over a period by the court, by different authorities for testing the infringement. Similarity in appearance, whether two products look the same. If it's exactly the same, there is definitely confusion. A person can be confused. There is this potential for confusion. So that will result in trademark infringement. The second one is similarity in sound, the idea, overall impression of the marks. So these things are taken into consideration while determining if it's an infringement or not. When we're talking about a landmark case, this is one landmark case I wanted to talk about, is Cadilla versus Cadilla. Because you are CLAT aspirants, you do not need to know the facts or the issues of the case in detail. You will be given the whole facts in the passage itself. So you don't need to occupy your mind with these things as of now. That will happen in law school. Till now, you just need to know what is the case, what is the important point about this case. It emphasizes the consumer confusion and adopted holistic similarity test, which is if overall the product is as similar to the other product, the infringing product. So these two similarities are very important, and it illustrates my previous points. So this case is a landmark case. In every infringement or every legal violation, I told you there is some remedy available. Similarly to copyright, we have injunctions, we have damages that you can avail, and additionally there are also criminal remedies, and you have seizure of infringing goods. So these things are some remedies that you can avail in case your trademark has been violated. Now moving on to the next intellectual property right, which is very important, is patent law. Can anyone tell me what is a patent? If not, let me help you. A patent is an exclusive legal right granted for an invention that is novel, non-obvious and useful. Let's break this definition down. What do you mean by exclusive? Exclusive means only belonging to you, only belonging to one person and cannot be used by any other person. So, when we're talking about an exclusive legal right, it means that something, some invention that a person has come up with, that it does not belong to any other person. It's specific to one single individual. So, that invention provided along with this, it has to be novel, which means that it has to be very different, unique. It has to be non-obvious. It should not be very obvious to a person. It should not be the obvious result of some process, or it should not be an obvious idea that could come into anyone's head. So, it should be that, and it should be useful. It should not just be in vain. It should have some industrial applicability. It should have some usefulness to the society. So, these three things, it's not and or. It is all three together along with the invention part that has to be there for a patent to exist. Only then a patent right is granted. When we are talking about the legal framework, it's governed by the Patents Act 1970 and it is administered by the Indian Patent Office. I would recommend you guys to just memorize the administrations it's governed by for your information. Now, the application process. In copyright and trademark, your registration was not important, and we saw which are the legal frameworks that administer it. Can you tell me? Yeah, let's recollect the copyright and the trademark administration administrators and the governing acts once again. So, for copyright, it was Indian Copyright Office, Indian Copyright Act 1957. For trademark, it was Trademarks Act 1999, administered by, I will leave it up to you to memorize that again. And for patent, it is the Indian Patent Office. It is enacted under the Patents Act 1970, and there is a specific patent application process that you have to follow. The process is very important in patent is because there are a lot of inventions that come into place every day. So, they have to check all these boxes, which is novel, non-obvious and useful. Along with that, it has to be inventive. So, that is why the patent application process exists. The first one is filing of your application. You come up with a new invention, which is all of the above. Then you go to the Indian Patent Office and file for it. Then it is published. After that, there is an examination whether it's fulfills all the criteria that is needed for it to be a patent. And then a pre-grant opposition is there. If anyone who has the same invention and is registered wants to oppose it, that chance is given, and then grant of patent is there. If there is no opposition of your patent and it is in fact unique, non-obvious and useful, then it is granted the status of a patent. Moving on, the rights of a patentee. It includes right to prevent others from making, using, selling or importing the invention. Like any other infringement, in patent also, the patentee gets the right that nobody can make its unauthorized use. They cannot, the patentee can always stop the others from selling it, from importing it and from using it. So, all these things are provided to the patentee. I have talked about what is the criteria of a patent, but let's see for your convenience what is it in detail. For example, the first was novelty. The invention must be new. There is another word for it, unique, right? Distinct and new, that does not exist already. It should not be published or known anywhere in the world. When you talk about anything unique, it means that it is originated instantly, or it is something that has come up which is not there previously. It has come up in a very original state. So, it should not exist anywhere in the world before that. Then, inventive step. It should not be obvious to a person skilled in the relevant field. For example, if you are coming up with a medicine, right, you want to get a patent for that medicine. a person who works in the same area as you should not also get a similar, idea or a thought or an invention. It should not be that obvious to that person. It should be completely different. That idea should be unique and come to you from your intellect. So the application of intellect is higher when obtaining a patent. And it must involve technical advancement. A very important point is technical advancement. It should not be of the similar status or stature. There should be some advancement that is included in this patent or this in this product. For example, the medicine I was talking about, the example. In that medicine development, there should be some technical advancement. Like for example, when you're talking about the COVID vaccine, there was a major technical advancement in that field, right? Similarly, in your patent also, there should be a technical advancement. Industrial applicability. So it must be capable of being made or used in some kind of industry. It's not as such that only you and you can make it. Yes, it should originate from you. Yes, it should be unique. And yes, it should be non-obvious. But it should be able to be made in a factory or an industry. So it should be industrially applicable. And lastly, non-patentable inventions. When we are talking about these three things, there's always one thing to be, careful about when a person wants to patent a certain invention. That is, there are certain things that cannot be patented. You can go ahead, read the Patents Act 1970. It's in the earlier sections of the Act. I'm eager to find out if you can find out which is the particular section that deals with this. So, for example, atom bombs, nuclear weapons, these things cannot be patented. Then there are mathematics, methods of mathematics, right? Along with it, natural laws, mathematical methods, business methods, these things are non-patentable. What else is non-patentable? Kindly let me know. We move on to patent infringement here and the legal framework surrounding patent infringement. What is patent infringement? I have taught you enough about what is copyright infringement, trademark infringement. Now you can tell me what is patent infringement. You guessed it right. It's the unauthorized use, making or selling or importing of a patented invention without the patentee's consent. Consent is a very important term in in IPR. Types of infringement can be direct, you all know what it means, or indirect, which is contributory infringement. Even if the person doesn't know that they are making a mistake or they are infringing someone's patent rights, they can still be held liable if they are contributing to that infringement. The third is legal remedies. When we are talking about legal remedies, again, injunctions, there are damages, there are accounts of profits and delivery up of infringing goods. These all remedies can be sought in case a patentee files for patent infringement in the court of law. The jurisdiction and enforcement, it's handled by civil courts. Appellate jurisdiction lies with the High Court. IPAB, it's a trick, this thing. IPAB, like I told you in copyright, it does not exist, it is abolished already. Okay, one of the most interesting IPRs is geographical indication, the GI tag. So geographical indication, as you correctly guessed, it relates to the geographical status of a product. Like I gave you the example, Darjeeling tea. So when you're talking about Darjeeling tea, obviously you know that the tea that originates in Darjeeling, which has made Darjeeling famous, it's the source, the source of the tea is Darjeeling. That is what makes it special. That is why Darjeeling has been awarded a GI tag for its specific tea. For example, Kanjivaram saris. There's a different state associated with that. Which state is it? Then we can also move to basmati rice. A few regions in the north and the west can be associated with basmati rice. This Pochampalli Ikkat, Telangana is associated with it. And there's Mysore silk. Sometimes GI is recognized with the name itself, for example, Mysore silk, Darjeeling tea, etc. But sometimes it's not so obvious. So don't get confused that only if the name is there, it means that geographical indication exists. That's not the case. Definition of GI is a sign used on goods with a specific geographical origin and qualities or reputation due to that origin, right? And the legal basis is governed by the Geographical Indications of Goods Registration and Protection Act 1999. Now the years are very easy. Trademarks Act is also, it was enacted in 1999, and so is GI Act. Now the famous GI tags I have already talked about. I am very interested to know which other GI tags you know of, and if not, you can research what are the latest GI tags that have come into place. In GK also, such questions are always placed before you. Geographical indications is not only a legal aptitude question, but in GK also you can get a passage about this, and current affairs can be asked about what, for example, black rice or red rice, such GI tags belong to which state. So you should think about a more holistic and a wholesome approach to this topic. And then benefits of GI tags. When you're talking about enhancing brand value, for example, when you're automatically Darjeeling tea, when you're talking about it, you'll prefer it over any other tea, right? So it will give you more importance. So the brand recognition will only increase. And then it protects cultural heritage. So a tea, a simple tea that originates from Darjeeling, it is giving the brand value. It is also protecting the culture. It's in fact uplifting the culture. So that is also one plus point of a GI tag, and it promotes rural economy. GI tags often, practically you can see, it originates from rural areas. It's not important that only urban areas in India have specific unique products that have originated from there. More often than not, it belongs to rural areas. So that is why these benefits of GI tags cannot be overlooked. Now you might be confused, it can be a little confusing to some about GI tags and trademark. What are the difference between those? Now trademarks refers to certain symbol, words or marks that could be distinctive or different. But GI tags refer to a regional origin. It's not the same. A product can be, as long as it's associated with a certain region, and that is why GI tag has been given to them. That is why both create brand value and recognition, but for different reasons. For example, GI tag promotes cultural heritage, trademark does not. Trademark only increases brand value and the recognition of the brand. But GI tag, along with it, it promotes cultural heritage and gives that specific region importance. Now Nike, you can have different stores across India. Many of you don't even know where the headquarters is. That's fine. But all across India, you will get Nike shoes. Darjeeling tea you might get in other places, but you know that it belongs to a certain state. So that's the difference. Ownership. Trademark is owned by individual or a company, whereas GI is a collective right for communities. The ownership is a very important mark for distinction. It's reserved for communities or producers at large, but trademark is a more private individual or company's ownership. When you're talking about nature of protection, trademarks protect branding, like I told you, and the GI protects a reputation linked to geographical origin. And lastly, when you're talking about duration and renewal, both are renewable, but GI is region based and not transferable. If you can recall, one important part about trademarks I told you is, with the consent of the trademark owner, you can transfer it for a certain amount of time and the person can use it. But GI, you can't do so. Darjeeling tea cannot be given to some other place, like it cannot be Sikkim tea, it cannot be belonging to Uttar Pradesh, it cannot be belonging to Kerala. So that is completely different. The product is attached to the region and it cannot be separated. We have talked about different acts that are concern themselves with the domestic regulation of such IPRs. But now we'll talk about an organization that deals with an international level of protection, that is VIPO. Now WIPO full form is World Intellectual Property Organization. Now this forum or this organization is very essential. We know about different international organizations, right? If you don't, let me explain it to you. When we're talking about international forums or frameworks, it's not important that our country ratifies it or signs an agreement, but India has ratified it, and there are different treaties that India has signed on. For example, PCT. Can you tell me what it is? Please comment in the comment box. Now, when we move towards the role of WIPO, we have talked about what is the full form, and you could have guessed that it is some authority that protects intellectual property rights on a more global level. But when we talk about coordination of international IP policy, protection and cooperation, it means that it sees that different copyrights, patents, trademarks and any other intellectual property rights do not overlap. There is no dispute regarding it on an international level. There is more protection and cooperation within the states, within 2 states or more. When we are talking about major treaties that come under WIPO, it is the Berne Convention, the Paris Convention, TRIPS Agreement under the World Trade Organization. Now these 3 agreements I've talked about, or the conventions I've talked about, it's very essential in different matters as well, like the environment law, other matters, for example. But when we are talking about trademarks, it's very essential to only focus on that part of these conventions. It's important to know what they represent. That is why I urge you to go more into detail when we are talking about Berne Convention, Paris Convention and TRIPS Agreement. You can take a look into it and get back to me. Now, India's participation, what is it? Even when we are talking about an international forum, you can focus back on India after talking about a general idea of international laws and agreements. In CLAT also, generally you will get questions about international frameworks, but it will essentially boil down to India's involvement in it or the role in some way or the other. So at least one question you will get out of that in this way. So India's participation is that it's a member of WIPO and signatory. I told you, PCT. So it's a Patent Cooperation Treaty. So if you're a signatory to a certain treaty, what does that mean? It means that you agree to the terms of that treaty and you're voluntarily agreeing to it. So you are recognizing the rules or the laws of that treaty, and you are taking that into consideration while making the laws in your country, right? So now impact on Indian law. Global IP standards influence domestic legislation and enhances cross-border enforcement. Like I told you, for example, PCT. If India is a signatory to PCT, it can come up with a law which is very similar to PCT or in compliance with PCT. That means that it has taken into consideration whatever it has signed on and it's actually working on it. That is how it will ensure there is a global IP standard with regard to this treaty, and also it will enhance cross-border enforcement. So even if not in the country, if you belong to any other country and both of those countries, you know, they are a signatory to this specific treaty, it will be easier to enforce. So that is what is important when you are talking about international frameworks. When we talk about recent case studies and legal developments in IPR, you must be thinking, why is it so important? Because I've told you, you don't need to memorize any case laws. But it's still important that you know about them and you recognize them. For example, if I give you any case law, will you be able to differentiate if it's a trademark infringement or a copyright infringement? That kind of concept clarity is essential when you're reading a question paper. In your CLAT questions, you'll get a passage. You'll have to link it to the questions and then you have to correctly identify the answer. So there might be a variety of similar answers or options. But if you recognize the question and the specific IPR correctly, there are high chances that you will get the answer correct. When we are talking about Amul versus Amul Cool in 2021, they both sound similar, right? But they are not. They are not the same company. It's not specifically Amul Cool, but a product that a different company was selling. But it's famously known as Amul Cool. Now, the court upheld the brand integrity, emphasizing goodwill and deceptive similarity. Can you tell me which IPR is it infringing? I am interested to know. Please tell me in the comments below. Second one is Novartis AG versus Union of India. This is easy. You must have heard about it before. If you have not, let me tell you. It deals with patent infringement. When you are talking about Novartis case, anyone from the law sphere will be able to tell you that patent infringement, it was a landmark case. It was a huge deal when the case happened, because here the Supreme Court denied the patent for a lack of therapeutic efficacy, which means that there is no development, no efficiency, that level of therapeutic efficacy that is needed in a specific invention, in a specific pharmaceutical invention. So this case was specifically dealing with a pharmaceutical company which was infringing upon the medicine of another pharmaceutical company. It was Falsitab and another product which also began with the word Falsi. So you can see how confusion can be created. Now, it was landmark in pharma IP, like I told you. That is why Novartis AG is something you should keep in mind always. Moving on to Disney Enterprises versus Parag Sanghvi 2019. By Disney Enterprises, you must have guessed that a copyright infringement has taken place. That's correct, because it also includes your dramatic works, your literary works, your cinematographic works. That is why here court upheld the copyright of a film dialogue, reinforced digital rights enforcement. So copyrights it's not included only in a very physical paper sense, but also digitally. So it's not very narrow. These rights are very broad and they include a lot of different things. When we are talking about these cases, there are several other landmark cases which you can look into if you are interested. And lastly, when we are talking about IPR policy, this is not a case law, but it's an important policy that came up in 2016, and the government initiative for streamlining IP registration, enforcement and awareness. What it does is, it brings about more awareness about IPR protection and for its enforcement and registration. Like I told you, can you tell me which are the two IPRs which are not necessary to be registered? You are correct. It's copyright and it's trademark. These two, IPRs, it's not important that you register them, but you always get additional benefit, legal benefit and financial benefit if you register it, because in case of an infringement, you have a prima facie evidence that you are the original owner. You don't have to go the extra burden to register it later on after dealing with the the mess of the courts. Now, that is why IPR policy 2016, it brings about awareness about its registration and enforcement. When you're just knowing about these topics it's very important, but it's not enough. You need to know about these topics, and side by side you need to see what are the trends in CLAT papers. In the previous papers, if you look into different categories, sections and also different topics, you will get to know that it often covers copyright duration questions, landmark cases and types of IPR. So these three things, areas you should definitely look more into, give special attention to. Legal terminologies is very important, except you can expect MCQs on terms like infringement, moral rights and public domain, not in the legal paper, but in GK paper if you are dealing with geographical indication questions. It's a chance that you might come across this, so it's not very essential, but you should always keep it in mind for your time saving techniques and your understanding. So that is something that builds on concepts and clarity in the future. Along with it, analytical questions. So scenario, we all know we get analytical and hypothetical critical based questions in IPR. So you will get a passage, then you will get a hypothetical question. You might get a hypothetical question and you have to answer whether it's copyright infringement or whether the duration of this is correct or not, some questions like that. So scenario based IPR application test legal reasoning and concept clarity. That is why we went through all these IPRs in detail. And emerging themes. Now focus on digital rights. Because I told you this is a digital era, new things are coming up again and again in this age. Digital rights have become pertinent. They have become so crucial that they are unavoidable right now. 10 years before, yes, you could have avoided that topic. But right now, more importance you have to give on digital rights specifically, along with your other rights. Artificial intelligence is also something. If IPR and AI are mixed together, if you get such questions, there are high probability, because AI also is being developed and redeveloped and modified with every passing day. So IPR and AI, there's a very there's a very good chance that you'll get a question about that. And a global IPR treaties. We have dealt with VIPO. Now remember the concepts I told you about international frameworks. You can apply that to other international frameworks as well, even if the facts are different. To conclude our concept today, we were dealing with empowering innovation, economy and legal integrity, right, when we are talking about IPRs. Now, importance of IPR in the modern law deals with creators' rights. It deals with not only protecting the rights in a very physical form, tangible form, which means what you can see, what you can hear, what you can see in front of you as a product, but also your digital rights, which is not there in a physical form, but in a very digitally, but it is present digitally. So that's also there, and it promotes justice, because if you are a creator of some property, of some product, and you are getting an exclusive right, that means justice is being done to you, correct? That you should get the exclusive right over it. So the fruit of your labor will belong to you. So that is what it means when we are talking about legal empowerment. The second is innovation and economy. When we are talking about patents, trademarks, copyrights or any other IPRs, you can name it, it means that it is stimulating a certain kind of innovation in the economy. Imagine there was no invention in the country. Where would our country be by now? There was no GI tag, no patents, no copyright, no trademark. There would be no development. The cinema industry, or be it the medicine industry, or be it anything, India would not be in the place it is today. Same applies to any other country. So these things are very important and essential for a country's development, for its economic growth and innovation. And additionally, it also boosts an individual's growth. Global competitiveness. Now, strong IPR regimes enhance international trade and technology transfer. For example, only your country has come up with a certain product and it does not exist in any other country, right? So you have you have some right over it, an exclusive right over it. So there are chances that you will derive a monetary benefit from it. Similarly, when you're talking about a global perspective, international trade is also possible. It will be boosted, and there will be a technological transfer as well if you're talking about digital rights. Legal career relevance. Now, apart from these 3 points which are very specific to IPR, talking about from a CLAT perspective, your future perspective, it's also possible that it offers dynamic specialization opportunities. For example, I have done my LLM in IPR and technology law. So that's my niche area. You can also delve into academics, you can delve into corporate firms, you can start your independent practice, you can only deal with one kind of IPR. There are varied opportunities there in the legal field for you. So IPR is not just a subject that you have to get over after reading for syllabus sake, but something that if you're interested in, you can delve deeper into it as per your interest. So that's all for today. We have learned a lot about IPR. I understand that it's a lot to consume, to observe and to memorize in one go. But I hope you got all the facts. If you have any questions, you can ask me below. And if you want me to explain about any other topic, that is also something you can ask me about. So that is all. Let's meet another day for another topic. Best of luck.